I'm very sorry for the delay in sitting. The fault is entirely mine. I was addressing a group of students from my home in Northern Ireland, and they asked me penetrating questions, most of which I wasn't able to give a sensible answer to. So I do apologise. Now, Mr. Simon.
Thank you, my lord. I trust if I'm unable to give satisfactory answers, your lordship
will. Oh, I doubt it very much. I hope there was no recording going on. Right.
Lords, when I left off, we were addressing the issue of the freeze order, which was granted pursuant to section 19B5 of the MLPA. What I would like to do, just in closing, is to indicate that following the application for the freeze order, the appellant filed an affidavit on the 18th of August 2009. So opportunity was given to the appellant to address the issue of the freeze order and to seek to get the freeze order discharged.
Yes.
In fact, following his affidavit, we had an affidavit from Ronald Christopher on behalf of the Supervisory Authority, and that your lordships will find at pages 247 to 255 of the record. And interestingly, attached to that affidavit are a number of exhibits, starting at page 257 to page 301. And what the Supervisory Authority did was to attach to his affidavit the earlier affidavits by the appellant, his girlfriend, and his father, which had been made in respect of the earlier freeze application, which was subsequently discharged. So that the court was given by the Supervisory Authority ample evidence from the appellant. And further to that, the appellant at page 304 filed a further affidavit with exhibits which extended to page 383. So that before Justice Harris, there was ample evidence on both sides, and evidence which he assessed, interpreted, and that allowed him to come to his conclusion that the freeze order ought not to be discharged because the appellant was unable to satisfy the onus of proof. And that onus of proof can be found in section 19B, subsection 6 of the MLPA at page 949.
Mr. Simon, can I just check? The impression I had was that the application to discharge the freeze order proceeded before the judge just on the basis of the affidavit evidence.
On the affidavit evidence.
But presumably, is this right that in an appropriate case, if it was necessary to hear live oral evidence, that could be a feature of such a procedure?
Indeed, it would appear that there was no application made in respect of live evidence to be given in addition to the affidavit.
Yes, thank you.
But the option is given to the appellant in those circumstances. So that it's not a case to say that the court will shut you up or tell you no. You do the affidavit and you can, for example, a lot of us would ask for an expansion of matters, to expand matters which are in the affidavit, and that opportunity is given.
Yes, thank you.
The 19.1 provides that the supervisory authority can apply to the High Court for the freezing order, and then the application is made ex parte. What were the circumstances in which Mr. Williams was putting evidence before the court in relation to the freeze order?
Right after the freeze order had been granted, and your lordships will recall that there is a 30-day limit.
Yes.
They were served on Mr. Williams. And in fact, there were two extensions of the freeze order because the end of the freeze order coincided with the court vacation. And there was a further extension which was granted, and Mr. Williams was able to take that opportunity and to file his affidavit in respect of that. Because your lordships will recall that the freeze order ceases to have effect after 30 days, unless by that time the defendant has been charged or an application for civil forfeiture order is made.
So were you relying on some rule in the rules of court to apply for an extension?
Yeah, well, yes, but in fact, I believe in this instance, the judge recognizing that the time frame was expiring on his own accord, granted the extension. So the order was passed on to the court. That is my recollection.
Thank you.
So the application for the discharge of the freeze order was filed on the 18th of August 2009, which should be found on page 209. Yes. The application itself is not in the bundle, but the affidavit in support of the application is in the bundle. And at page 209, the first paragraph of the affidavit reads, from the appellant and the applicant hearing, I swear this affidavit in support of the application made on my behalf under the provisions of section 90B, 5D of the Money Laundering Prevention Act as amended.
And the date of the application?
It does not state, but I would want to think that it was made on the very same date. It's normally when we file an application, the supporting affidavit is filed at the same time.
Thank you.
But his affidavit makes it very clear that it is in support of the application that was made.
It appears that the authority did apply for an extension of time, if you look at page 206.
I'm guided by
Well, it says, upon application of the claimant made orally. Page 206. It's the first recital, I think, to the order.
Yes. Yes, the authorities did. I'm thankful for that guidance. The return date was then extended to the 31st of August. And the application was filed on the 18th. And I was mentioning that section 19B, subsection 6, which can be found at page 949, provides clearly the onus of proof in an application made pursuant to subsections 4 or 5 lies upon the person seeking relief under those subsections. So the onus of proof would have been on the appellant. Having assessed the evidence on the affidavits, Justice Harris determined that the stay would remain because it was well-founded. Now the the freeze order being in force, the application was then made for civil forfeiture of the appellant's properties. There is no question that the properties belonged to the appellant because he was registered as a proprietor on the land registers as filed at the land registry. Now at page 951, my Lord, we have Section 20, capital A, subsection 1. Comes under Part 4B, and that deals with civil forfeiture. And sub 1, if a freeze order is enforced under Part 4, the supervisory authority may apply to the High Court for a civil forfeiture order, forfeiting to the Crown all or any of the interest in property that is subject to the freeze order when the forfeiture order takes effect. Sub 2, the High Court shall make a civil forfeiture order if the court finds that it is more probable than not that the person in respect of whom the freeze order was made had at any time, not more than 6 years before the making of the application of a civil forfeiture order, engaged in money laundering activity. The civil forfeiture order was made on the 5th of August 2009. When we calculate 6 years before that date, it takes us to the 4th of August 2003. That subsection 2, does not create a link with the acquisition of the property by unlawful activity. All it simply states is that the defendant, now the appellant, once there is a freeze order in effect, then the civil forfeiture application can be made once it is proved that within the last 6 years he was engaged in money laundering activity. So that is where the 6-year period comes in. Was the appellant engaged in money laundering activity within the last 6 years? We know that the appellant was found to have engaged in money laundering activity during that period because of the charges and the conviction. So that the 6-year limitation period was established. And the onus would then be on the defendant, or the appellant here, to satisfy the court on a balance of probabilities how he acquired his properties.
Right.
Mr. Simon, could I just ask you, if you look at 20A1 and 2 together,
That's right.
20A1 talks about the authority being able to apply for a civil forfeiture order, forfeiting all or any of the interests in property subject to the freeze order. And then 2 provides that if satisfied in relation to the matters which you've just described, the court shall make a civil forfeiture order, but it doesn't say whether the court has to make it over all the property in the freeze order, or all the property for which the authority applies, or has a discretion as to what property to make it over. Is there any other provision that fills that gap?
There is no other provision, but I think the mere fact that the application cannot be made unless there is a freeze order in force would bind the supervisory authority that it could only make that application in respect of the properties that were subject to the freeze order.
Well, that's undoubtedly right, but I think His Lordship's point is that subsection 1 of 20A refers to the application for forfeiture of all or any of the interests within that freeze order. And I think the question is it open to the court to say the freeze order covers 10 properties? I think it's appropriate only to order the forfeiture of 5.
Yes, if at the end of the day the court finds that the defendant or appellant, in our case, does not satisfy the court that the properties, the 10 properties that he has in his possession or he has interest in, were not obtained by unlawful activity.
Well, can I just give an example? Suppose the court makes a freezing order in relation to all the defendant's property, which it can do under Section 19. No application is made to take property out of the freezing order under 19B5 or whatever it is. And the defendant doesn't turn up to the forfeiture order application. But it's apparent from the evidence in support of the conclusion that he's been involved in money laundering, that the evidence only goes to money laundering during, say, 6 months before the freezing order is sought to be obtained. But it's also apparent that he's owned property for, say, 30 years, which on the face of it wouldn't have anything to do with the evidence in support of his money laundering activity. Could the court simply say of its own motion, well, I'm not going to forfeit that property because it would just be, for example, disproportionate?
I'm being, my junior is now drawing my attention to 19B1 at page 943.
Sorry, 19A1.
Section
19B. Section 19B, capital B,
Yeah.
subsection 1,
Yeah.
at page 943.
Well, that tells you what property the freezing order can be made over, doesn't it?
And they can vary it, yes.
And it can be varied.
Where are you looking at? Yes, where the High Court makes a freeze order, the court may at any time, when it makes the freeze order, or at any later time, make any ancillary orders that the court considers appropriate.
Yeah.
And without limiting the generality of the court's power, the court may make any one or more of the following orders. And there the court can vary the property to which the freeze order relates.
So is that the procedure by which the property subject to a CFO can be reduced or limited?
Yes, ma'am.
Right. Thank you.
Seems very clear on that.
So you're accepting then, and this may be important, you're accepting that the court has a power, a discretion, even if your authority is applying for the forfeiture of all the property, the court has a discretion to exclude something from the freezing order. For example, to use Lord Briggs's example, if it isn't satisfied the property is linked with the unlawful behaviour.
Yes, it appears that
even if the onus isn't discharged by the
defendant. It would appear so. Respectively. So it does have that power that it can exercise in that respect.
But we don't see that anywhere in the statute.
It is in there. So 19B1, we are saying, gives that authority. It's at page 943.
So you say at any later time would include on the hearing of a forfeiture application. And since the forfeiture application can only bite on what is frozen at the time it takes effect, the court could therefore reduce the size of the scope of the freezing order, and that would automatically reduce what was forfeited.
Indeed.
Yeah.
I do wonder whether the court would be proceeding correctly in that situation.
Well,
given the structure of Section 20A, subsection 2, which seems to impose an obligation on the court to make a civil forfeiture order if something is covered by the freeze order, and where the statute itself sets out the basis on which things can be taken out of the freeze order.
Well, taking over the freeze order under 19B1 appears to me that could be exercised before the civil procedure, before the civil forfeiture.
Yes, I don't have a difficulty with that as the timing, but Section 19B 4 and 5 seems to set out the basis on which the court would remove property from a freeze order. So I think that my Lord was putting to you a situation, the defendant or a person interested in the property can't satisfy either the requirements of section 19b, subsection 4, for a person interested in the property, or 5 for the defendant. But nonetheless, could the court
And still
cut it down?
cut it down.
Yes.
And I have no doubt that the court, of course, would give an opportunity to the supervisory authority to respond to that initiative that it would certainly adopt.
I wonder about that. I mean, the terms of section 20A, subsection 2, appear, at first reading, to be mandatory, do they not? The High Court shall make a civil
Providing that it finds that it is more probable than not.
Yes, but it has to make that finding. But once that finding is made, does it have any discretion?
Does, my lord, upon the application which made by the defendant in those circumstances.
Perhaps we don't need to take up too much time on it, but I do wonder whether the court has some discretion over and above acting in accordance with its findings under section 19b, 4 and 5. So what's being put to you is, as I understand it, is defendant can't satisfy the court under section 19b5 that he owns the property from proper sources. So he's failed in that defence which the statute provides for. But nonetheless, the court would retain some discretion not to make to discharge the freeze order and therefore not to make the forfeiture order.
I never addressed that issue, but I'm just thinking aloud that it's possible, for example, that if the property was acquired 15, 20 years ago, the defendant may not be able to produce any documentation to show a link between funds which he legitimately has and which he acquired the property then, and I could see the court exercising its discretion in those circumstances.
Well, all right. I question that because that would just be a situation where the defendant has failed to discharge the onus that's put on him by section 19b5.
Well, I suppose the opening words of 19b1 may give the court some discretion. When the High Court makes a freeze order, it may at any time make any ancillary orders that the court considers appropriate, and without limiting the generality of the court's power, it may make certain orders. There does seem to be some flexibility there.
Some flexibility, some discretion. Don't know if your lordships may want me to do a little more research on that and file submissions specifically relating to that issue.
Well, I think, as my Lord Sales has said, it was probably not worthwhile spending a great deal of time on it, but 19b1 invests the court with the power to make an ancillary order, but that's ancillary to the freeze order that is already made.
Yes, yes, my lord.
Whether that is sufficiently broad to allow discretion to reduce the impact of the freeze order is another question. All right, let's move on anyway.
A.
And then if we look at 20A9, which is on page 952, any person notified of an application pursuant to this section is entitled to appear and give evidence at the hearing of the application. But the failure or absence of that person to appear and give evidence does not prevent the court from making an order under subsection 2. So it makes it very clear that the defendant in those circumstances will be served, has notification, and then he can then make his necessary application. But if he fails to do so, or in his absence, it does not prevent the court from making an order under subsection 2. Now, section 20A3 finding of the High Court for the purposes of subsection 2 need not be based on a finding as to commission of a particular offence and can be based on a finding that some offence or other constituting a money laundering activity was committed. So it doesn't have to relate to any particular offence, which is where poker in Antigua certainly does. And may I just indicate that the Money Laundering Act in respect of a civil forfeiture continues to be enforced side by side with the poker legislation. So we have in Antigua two options in respect of civil forfeiture. Then Justice Henry's judgment appears at page 628 to 639. But let me indicate that we have a range of affidavits which were filed by the appellant. At page 416 is the appellant's affidavit, along with 10 exhibits, taking us right up to page 470. Then we have an affidavit by his girlfriend, Idrissa Andre, at page 471, attached to which are 3 exhibits. And at page 499, his father, Watty Williams, files an affidavit. And at page 503, the appellant files a supplementary affidavit. So it cannot be said that the appellant was not given or did not take the opportunity of ensuring that his evidence of how he was able to acquire these two properties was before the court.
Well, I don't think that case has been made against you, has it?
Yes.
It hasn't been suggested that the appellant was deprived of the opportunity.
No, it was not. But it's just that the question had been raised as to whether it's done on his own initiative or not. So it's right there. And Justice Henry's judgment, I will not go through it with your lordships, but it makes it very clear that she was not satisfied. Because there was no link, number one, in respect of, how should I put it, where the monies came from to purchase the properties, notwithstanding the fact that his girlfriend worked at a bank. And she indicated also that she had a fixed deposit, but the fixed deposit was subsequent to the purchase. Then, in his supplementary affidavit, the appellant indicated that they kept a safe at the home.
Yes, well, I think we're probably...
So, we have all of that before us, as well as his seeking to indicate that he had income coming from his employment, and that was found very wishy-washy, meaning not substantiated at all. So it is on that basis that the civil forfeiture order was made by the court. In fact, we also have a situation where the girlfriend says that she had an interest in her affidavit and gave as an excuse the reason why her name was not on there is because she was so busy at the bank and didn't find the time. And of course, that has been dispelled by Justice Harris, because that was totally unnecessary. So, my lords, it's on that basis that was made. And I will wrap up by simply saying that what the respondents say is that the basis of the grant of the freeze order and the CFO is the evidence contained in the affidavits of Ronald Christopher and starting with identifying the appellant in the car, motor car, where the monies, the drugs, and firearm were found. We say that that case falls squarely within the legal principles established in the case of Gale. My learned friend will go through that more particularly, but we refer your lordships to paragraphs 40 and 44 of Lord Phillips' judgment, and Gale is at tab 16.
Yes.
All of the respondents' authorities.
Yes.
Yes. And we also indicate that there clearly was no link between the criminal proceedings and the civil recovery proceedings. It was not necessary for there to be a finding of guilt in respect of the committal of any criminal offense once it is established that he was involved in some criminal activity. And finally, we see in relation to the freeze order in the High Court, if we look at page 396, paragraph 38 of Justice Harris's decision, he makes it quite clear that he found weaknesses in the inherent consistency of the defendant and explanations. And, quote, I am not satisfied that the documentary evidence shows a lumber import business activity or income generating capacity. I will now leave it to my learned friend to address
Thank you very much indeed.
the issue of constitutionality.
Thank you.
Thank you, my lords.
Ms. Artesi.
Yes. My Lords, on behalf of the respondents, I make submissions in relation to the issue of the whether the criminal forfeiture regime under the MLPA, which I refer to as the CFO regime, is civil as distinct from criminal. But if I may, could I attempt to possibly deal with a point which the respondents say goes to the whole question of proportionality of the CFO regime, which was raised by my lords in the context of the statutory provisions under the civil forfeiture, section 20, capital A, at page 951, and whether that has powers for the court to vary the interests of the property. Well, what you have at section 20, capital A, subsection 9, at page 952, is, of course, the opportunity for the person, in this case Williams, to be entitled, a strong word used there, to appear and give evidence at the hearing. So we pause there. Of course, the point there is there's an entitlement to produce your side of the story and rebut the presumption that the property may have been engaged in money laundering activity. You then go back to the previous page at section 20, capital A, subsection 4, and what is said there is the CFO must bite in relation to specified interests in property. And my lords, the point on behalf of the respondents I make there is those two sections read together must demonstrate that the High Court judge on the CFO application has the jurisdiction to first hear the evidence of Williams, and then second, it must bite in relation to specified interests. So the judge must be satisfied in relation to the evidence the order is making is in relation to that interest that bites on satisfying the test on the subsection, under section 20, capital A, subsection 2. So, my lords, moving on, the respondents adopt the reasoning of the Court of Appeal, which is set out at paragraph 71 to 80 of the judgment, found at pages 744 to 748 of the record, but with some further points. The attack under this head, my lords, is centered around the proposition that the target of the civil forfeiture CFO regime on the MPLA is at the person, in this case Williams, I refer to him as, and not the property, and that's set out in the appellant's case at paragraph 59, page 792 of the record. And the appellants say that the basis of this contention is that the freeze order was obtained on the basis that Williams was convicted of a Section 6(3) MDA offence, which is now accepted by all the parties, was a money laundering offence at the time. But what the appellants say, he was not, in fact, convicted, reprimanded and discharged, and so therefore that doesn't bite. My Lords, the respondents say in answer to that the target of the CFO regime under the MLPA is the property, but it is necessary to establish the criteria for the grant of the freeze order that Williams engaged in a suspicious activity. A corollary attack is that the CFO regime under the MLPA is analogous to criminal confiscation proceedings on the Part 5 POCA or Antigua and Barbuda without the corresponding safeguards afforded to defendants under those regimes. And my Lord, pausing there are significant differences between the POCA, Antigua and Barbuda, which I refer to as that, and the CFO regime under the MLPA, just to list 5. On the POCA, Antigua and Barbuda, it's necessary to prove a link between the property in respect of which recovery is sought and unlawful conduct. Under the CFO regime, there is only a need to prove a suspicion of engaging in money laundering activity. Property does not come into equation at that stage. Second differentiation is there are limitation provisions on the POCA, Antigua and Barbuda, which provides property can't be recovered for more than 12 years from when the property is obtained. And that's at the Appellant's Bundle of Authorities tab, Bundle 1, tab 7, page 1058. There's a section 60 VV of POCA in Antigua and Barbuda. Again, the obtaining of an interim freeze order on the POCA, Antigua and Barbuda is not required. But under the MLPA, interim freeze order is a necessary precondition to going along to getting a CFO. So the process is interim freeze order, that's the ex parte. Then you have the return date when the thing is heard, and then you have the CFO. And the effect, as my Lords rightly picked up, of the freeze order is simply temporary, and it prevents disposition of the property, pending the court having an opportunity to make a determination of the suspicion of the ONDCP against the factual evidence provided by the defendant.
What happens if the freeze order is made, someone is charged, and then the charges are dropped?
Well, that's where we get back to the whole question of, yes, I know, statutory interpretation, respondents say, because if you look at 2H, which is the definition of money laundering at page 917 of Bundle 1 of the Core Bundle of Authorities, you'll see that money laundering activity is defined as anything done by the person. So in this case, what the respondents say, the things done by William was the whole facts, I call the incidents collectively, which were read out by my learned friend Mr. Simon, being found in the car, identified by the police, the 3.3 kilos of drugs.
I'm not sure that addresses my Lord's question. I mean, he's asked you specifically what happens after the freeze order is made where the charges are withdrawn.
Yes, well, according to Section 2H, even if the charges are withdrawn, tried or acquitted or quashed on conviction, it still bites. And so that goes to the breadth of Section 2H. It is wide.
But what happens to the time limits? Suppose that a freezing order is made on suspicion. There's then a charge within 30 days. And 60 days later, the charge is dropped.
But what you would have
You'll be out of time to make a forfeiture order from 30 days after the date of the freezing order. How does the whole structure then work in that situation?
Well, you'd have to have there was extension given. So assuming there was no extension to the freeze order, it ceased to exist, so it falls away.
The moment the charge is dropped?
No, 30 days, sorry, I'm
Yes,
reference to the 30 days.
I'm sorry, say you have a freezing order,
yes,
then a charge,
yes.
and then 60 days after the freezing order, the charge is dropped. Does the freezing order fall away the moment the charge is dropped?
No, it doesn't. And
Why not?
Sorry? Yeah,
Otherwise
well,
it could go on. Otherwise it could go on forever.
That's a different point. The 30-day point is a different point, as I understand it.
That was the point I was asking you.
Yeah.
My query is there, it's not related to the facts of this case, because what we have here is an application for a civil forfeiture order within the timescale that the court allowed with its extension. But if we're looking at the constitutionality of the legislation, what Lord Briggs was asking earlier, and what I'm following up now, is what is the position if, as he says, within 30 days someone was charged, but thereafter the charge was dropped? How does the freeze order come to an end?
My understanding is once the definition of Section 2H provides once the suspicion of money laundering activity has been established in order to found the freeze order. Going back to Gale, this is exactly what happened in the case of Gale, my lords would recall. The charges, Gale was acquitted in Portugal, and POCA under Part 5 UK, the UK authorities sought to have a civil recovery order against Gale, relying on the facts of the matters that founded the criminal offence in Portugal and Spain, but in respect of which he was acquitted. And the House in this country said, well, as long as there were safeguards in the system, it is properly appropriate for a civil court to use the same facts which were dropped in a criminal proceedings to find a civil recovery proceeding. And the reason is there are many reasons why the charges might have been dropped in a
Of course, but can I leave it with you to for the supervising authority to think about it and perhaps come back to us as to what happens to a freeze order if a charge is made within the 30-day period and then dropped?
I rather think that you think it doesn't make any difference.
No, but my lord, I answered the question with Gale, if I may, because that's what happened in Gale. Could I take your lordships to Gale?
Well, I think we're very familiar with the circumstances in Gale, but it resolves, does it not, to your submission, that it doesn't matter if the charges are dropped?
No.
Well, it doesn't matter in the sense that proof that at the forfeiture stage, that proof that the requisite money laundering conduct or activity can still be achieved. I can entirely understand that. My only concern is really a procedural one, which is what happens to the freezing order. Can I leave you with a possible solution, which is that if the order of events is freezing order, 20 days later charge, 50 days later charge dropped, it may be that the original freezing order goes, but there's nothing to stop you applying for another one.
Yeah, but you extend, which is what happened, you extend the freezing order.
Well, maybe you have the power to extend it.
Yeah, because you have 30 days, and on your analogy, you have 30 days, so at the 30-day point, because the charge hasn't been dropped until the 50th day, 30-day point, you're on day 31, well, of course, you apply well before that, you get an extension, you get to within 20 days of the next block of extension, next 30-day period, charges drop, it makes no difference for the purposes of the civil proceedings and establishing on the balance of probability that the suspicion of money laundering.
Well, just to make sure there's no doubt, I mean, what I'm looking at is section 19A2, which on its terms seems to suggest that the freeze order ceases to have effect after 30 days unless someone is charged. Now, all I'm wanting to know is, if someone is charged but that charge isn't proceeded with, how does the freezing order come to an end? But I'll leave that with you. We can come back to it. Because it doesn't affect...
My lord, my first answer to that is I've given the answer in the context of Gale. It doesn't matter. But my lord, I will go away.
But no, the reason I ask is because an attack was made on the freeze order regime, and part of the answer was, well, it's only temporary. And I'm wanting to find out is, how temporary is it necessarily?
There seems to... The point is that there seems to be a gap, just looking at the provision of section 19A2 and the bit at the end, in what is obviously intended to be a procedural protection for the defendant, that a freeze order will cease after 30 days. But what my lords are putting to you is that one can imagine a situation where, as they say, it's originally obtained on the basis of suspicion, but then someone is charged, so that means that the protection of stopping after 30 days doesn't apply. But then the charge is dropped, and that just seems to leave the freeze order existing permanently through time.
My Lords, I think it may be, because if we can go back to section 2H, there's on the basis, the way in which the appellants have put the case, they seem to, I mean, it's been said there's a link between a money laundering offence or charge and money laundering activity, establishing, the respondents say that's not correct. And the reason why perhaps there's some sort of confusion about what may happen after 30 days is because even if a charge is dropped, the respondents say there's no link between charges because of the definition. And again, if I can take you back to the definition at page 917 2H, it simply says whether or not a person has been charged, and if charged, tried, or if tried, acquitted, or have been convicted and even quashed or set aside. Now, I accept that means the respondent need to demonstrate on the well-established principles that given the wideness of this statute, there are safeguards in the civil recovery system. But my Lord, what the respondent says, the section is so wide, it is not related to, it's not coextensive to have a charge or an offence, a criminal offence, in order for this section to operate. It is wide. And that brings me back to the principles of statutory interpretation and looking at the Act itself and even applying the Engel criteria, my Lord, when we look at it. It comes down to a question, the respondents say, of proportionality, and if there are safeguards in the system, that the defendant has an opportunity, Williams in this case, at each stage, to come along and say, well, actually, no, here is my proof of X, Y, Z. I have a job, I'm earning this much, I have a lumber business, this is the accounts for it, because we're only looking at 6 years here in terms of the engagement of the suspicion in money laundering activity. What's happened in this case is that Williams had that opportunity, both at the freeze order stage, and you've been taken to the affidavits, but there's nothing, certainly when one reads the judgment of Mr. Justice Harris, which sort of crystallizes and analyzes the evidence going to the suspicion of money laundering. There was nothing that the judge was satisfied with, that the Ahmed had discharged that rebuttable proof to show, Williams, that he was not engaged in money laundering activity. So he has that, the judgment of Mr. Justice Harris appears at page 385. It starts at 384 of the record. And you will see that he goes through the affidavit evidence of Williams. So going to the question of proportionality and safeguards and within reasonable limits, having regard to what's at stake and the rights of Williams, he goes through the evidence. Williams had an opportunity to produce evidence. And what he says is crystallized at paragraph 38 at page 396. I note the basis for the claimant's suspicions of the defendant's money laundering activities are not limited to the charge and conviction of the defendant by virtue of section 19.1 subsection C. So he's dealing with engagement. This is not a 19.1A application, and I think that's the other confusion that's been put in the minds of the board. This is a 19.1C application, and the judge addressed this as such, and he says they rely on a number of historic activities and other things, but on the evidence, I find weakness in the inherent consistency of the defendant's assertions and explanations. I'm not satisfied that the documentary evidence shows a lumber import business activity or income generating capacity as alleged by the defendant. Then he deals with all the evidence. So he deals with, so Williams had an opportunity in terms of, yes, the section is wide, it doesn't matter if you charge, but then are there safeguards? And respondents say yes. He has an opportunity at this stage to provide evidence, and it's all in there. And then the freeze order is made, yes, that's temporary, but then we have another opportunity again. We have the forfeiture order, and he gets notice again. There are notice provisions. So he gets notice of of the application. Now, the process of the CFO regime is outlined at paragraph 10, pages 5 and 6 of the respondent's case, so I'm not going to go through it. But he gets notice, and then we come to, he puts in more evidence, and the supervisory authority also puts in more evidence. And we then get to the judgment of Madam Justice Henry, which is page 638 of the record.
Which page, sorry?
638 is the relevant
Passage.
but it starts at 628. But the relevant section of the judgment, you see, it's actually headed, did money laundering activity take place within the specified period? That is the test the judge had to satisfy herself about. And she looks at the evidence in relation to that. What she says at paragraph 47, the court has found that it is more probable than not that Mr. Williams engaged in money laundering activity on the 21st of November 2007, the date of the commission of the offence for which he was charged. The application was filed in August 2009. But engaged in money within the specified date, he acquired the property is not a date Williams acquired the property is not a relevant consideration under Section 20A, and the prosecution need not prove the properties were acquired from the proceeds of a specific crime. And that is exactly the difference between a proceeds of crime confiscation regime and a civil recovery regime. And in particular, in relation to the state of the evidence, at paragraph 40, the judge said the evidence does not explain the large amount of cash used in the purchase of the properties. Having reviewed the evidence, the court finds there is no documentation of the source of cash to purchase the land or why the banking system was not relied upon, especially since Ms. Andre was herself employed in the industry. So that was the second opportunity in terms of the proportionality and taking into account Williamson's right, what's at stake, and the penalty. So the respondents cannot shy away from, yes, Section 2H is wide, but that is what it is. Charge is not necessary on any sort of criminal conviction, and that is the distinction with this system. So the respondents say what the board needs to be satisfied about is it proportionate? Does it take account of Williams's rights? Has he had an opportunity? Is it within reasonable limits and proportionate? Now, the answer to that must lie primarily in the statute itself, the enactment, the MLPA, and of course, the tests for determining whether proceedings are civil or criminal, quite apart from the words of the enactment, is the Engel, application of the Engel criteria, which courts are well familiar with. And it's quite clear on the face of the MLP, if one looks at the beginning, and it says it's an act to prevent money laundering. That's the purpose. That's why in the preamble, page 907, bundle 1 of the Appellant's and Justice of Appeal Blenman, at page 745 of the record, paragraph 72 of her judgment, also restated the principle that the primary indication of legislative intention is legislative text, and this one actually, that Antigua and Barbuda Parliament is assumed to be rational and informed. They're pursuing a clear purpose in a coherent and principled manner. Now, the MLPA at sections 28 D, A and D, specifically state that the proceedings are civil in nature and the test is the balance of probability. 28 A and B are at page 962 of bundle 1. That's the starting point, the respondents say. Helpfully, in the Respondent's bundle, tab 1, there's a copy of the Interpretation Act of Antigua and Barbuda, cap 224, tab 1 of the Respondent's bundle of authorities, and cap 224 at paragraph 36, sorry, section 36, the section is headed Construction of Enactments. Every enactment shall be construed as always speaking. And then moving on to 38, section 38, acts are to be given a remedial construction, and in particular, as such shall be accorded to receive such fair, large, and liberal construction and interpretation, the last 3 lines, as will best ensure the attainment of the true spirit, intent, and meaning. My Lord, what the respondents say is the MLPA, the relevant sections, are to be given a large and liberal interpretation as opposed to a narrow one. And of course, at section 40, that the definition of or rules of interpretation contained and apply to construction of provisions, the enactment that contains such definitions or rules, as well as any other enactment. Definition of 2H, it is submitted is to be as set out in the MLPA. My Lords, there is also reference to the case of Jennings in the respondent's case, which is at tab 10 of the respondent's authority, and the Jennings case involved an employee of a company who was used in a fraud, and there was a restraint order placed over his assets, and he sought to discharge that order, and the court found there was sufficient grounds to sustain the order. The relevant paragraph, however, I wish to take the board to is paragraph 13, what Lord Bingham of Cornhill said.
Which page, please?
I'm sorry?
Which page, please?
Well, it's the respondent's bundle of authority, so it's not in the, I'm not sure if it's in the appellant's bundle. No, but the page is different.
It has, it's 206 of the bundle in the internal.
Yes.
So it's in the respondent's. It's only in the respondent's authority. So it's not on the. It's not on the electronic bundle, my lord.
Well, it should be.
Well, is it?
Well,
There was
if you give me a page number, I may be able to find it.
Well, let's waste time on it. Sure we'll be able to find it.
There was
That's
a
all right.
difficulty with taking in the authorities from the respondents. I'm not going to get into that. If my lord, if you can bear with me, I apologize to the court. Tab 10 of the respondents' authorities, you'll see Jennings there, and the page of Jennings, which contains paragraph 13, is page 206 at the bottom. It's a 2008 case, 1 appeals cases. 1046. Could we go to page 1051, please? Paragraph 13 deals with the question of statutory, in the context of statutory interpretation, and that the focus must remain on the language of the section, and that care must be taken not to substitute with language, plain English for the legislation. My lord, that's the only point I wish to make in relation to.
I see. Thank you.
Jennings. So, my lord, I've taken the court to the express statutory provisions in the MLPA in terms of the Engel criteria, classification of the relevant provisions of the MLPA. They're well-known proceedings on the national law 1, second, essential nature, and the third one, the type and severity of the penalties which a person potentially exposed. Now, my lord Kerr has indicated that he can't quite remember the case of Walsh, and I
think that's putting it benevolently. I can't remember it at all, but I reminded myself of it.
My lord, I'm hoping to remind you quite vividly.
Well,
as
I
it's a case-
have looked at it again.
as it's a case relied on heavily by the respondents, both in the Court of Appeal, Justice of Appeal Blenman relied on it heavily, and indeed today the respondents rely on it heavily, for a simple reason, my lords, all the cases, the majority, not all, the majority of the cases that the court has been referred to in the index, in the bundles before you produced by the appellant, are all dealing with confiscation regimes on the Part 5 of POCA. There are only 2 cases dealing with civil recovery, and Walsh is the only one where you have a jurisdiction which is somewhat akin to the Caribbean, so slightly linked to England, but having their own statutory regime, which is civil entirely. And so Walsh offers the greatest assistance when comparing that system with the MLPA system and dealing with the criteria to really say, is this system civil in name and nature? So I'll briefly remind my Lord Kerr about Walsh, if I may. It's a case which my Lord Kerr decided when he was then Lord Chief Justice of Northern Ireland.
Which bundle is it?
Yes, it's page 1754, which is tab 31.
Thank you.
Of the bundle 2 of the authorities, core bundles of authorities. And that is, citation is 2005 NICA 6 report. The brief facts of Walsh were that Walsh was acquitted on 4 counts of theft, and the police and the Asset Recovery Agency believed certain items of Walsh's property were derived from criminal activity, and the agency therefore applied to the High Court under Part 5 of POCA 2002, which provides for civil recovery of the proceeds of unlawful conduct. And Walsh contended that unlawful conduct must be proven to the criminal standard if the proceedings were to comply with Article 6.2 of the ECHR. And it was held that the 3 Engel criteria, the classification of proceedings in national law, essential nature, seriousness of the potential penalty, governed whether proceedings were civil or criminal. Now, my Lord, similar points have been raised in this case of Williams, albeit in a different but not widely dissimilar statutory framework, the respondents say. And the issues in Walsh were, 1, whether the recovery proceedings were to be classed as criminal, and that's been raised here. 2, whether a finding of unlawful conduct in civil proceedings amounted to a finding of a criminal offence without the safeguards afforded, that is, finding it to the criminal standard of proof beyond reasonable doubt, and that's a point taken here. And of course there were the allegations of breaches of the right to fair trial on the Article 6.2, and of course the concomitant loss of presumption of innocence, which you would be afforded if you charged under a criminal offence. And here the breach is put in terms of Section 3, liberty of person, and Section 15.1, fair hearing, when charged with a criminal offence in relation to the Antigua and Barbuda Constitution. Now, my lords, if I can take you to paragraph 27 of Walsh, which is at page 1754 in the bundle.
17.
That's not 20, that's the beginning. So.
76.
Yeah, 1764. I hope my Lord Kerr doesn't mind me simply saying Lord Kerr rather than going into Lord Chief Justice Kerr, as he was then. At paragraph 27, what is said is, we are satisfied that all the available indicators point strongly to this case being classified in the national law as a form of civil proceedings. Why? The appellant is not charged with a crime, although it must be shown he was guilty of unlawful conduct in the sense that he acted contrary to the criminal law. But this is not the purpose of making him amenable, as he would be if he had been convicted of a crime. He's not liable to imprisonment or fine if the recovery action succeeds. There is no indictment, no verdict, and the primary purpose of the legislation is restitutionary rather than penal. My Lord, applying that first criteria to the facts of this case, contrary to the assertions of Williams, made on behalf of Williams, there is no charge
No, but I think the point that Mr. Taylor makes is that unlike Walsh, where restitution was being made or being sought to be made, here there's no connection between the amount to be recovered and the amount that has been generated by the criminal activity. Therefore, it isn't a question of restitution, it's a question of imposing a fairly swingeing penalty.
My Lord, what the respondents say, it's preventative, and there are authorities looking at that. I'm simply dealing with the three Engel criteria. Of course, there is a point that the Engel criteria arises out of European law, and query to what extent that ought to be used for interpretive purposes for the legislation in Antigua and Barbuda, but what the respondents would accept that the principles of proportionality clearly bite.
Yes, but that doesn't really meet the point that I think Mr. Taylor makes, and that is, this is distinctly penal in nature. You're not looking to recover the proceeds of a crime. You are simply using I was going to say the pretext, but that's not the right word, but using the circumstance that it can be shown that he was engaged in money laundering activity to impose a very heavy penalty upon him. So there's no link, as there was in Walsh.
But my Lord, as I understand the position under Part 5 of POCA, other than the link in terms of the unlawful conduct and the property obtained, there is no link in terms of the amount of the property and the money, in terms of counting the money.
Is that right?
Can we take an extreme example? Suppose the suspicion or the conviction is of possession of a very small quantity of drugs with intent to supply it to the defendant's brother, not for payment or anything like that. That would still fall within Section 6. It would therefore be a money laundering offence, even at the time.
6
of the Misuse of Drugs Act. And it would therefore be within the definition of money laundering offence. On the basis of that suspicion, what is there to stop the authority going to court for a freezing order over the entirety of that defendant's property on the basis that he owns it, he's got an interest in it, and then forfeiting the lot? And you may say, well, look, the defendant can come back and prove that he got his property by legitimate means. But as your colleague pointed out, it may have been acquired many years previously, and he may no longer have a means of proving how he paid for it. And there'll be a complete disconnect between the consequence for him and any money laundering that might sensibly be thought to have arisen out of a possession of a very small quantity of drugs with intent to supply it to your brother.
My Lord, the answer to that must be that the proportionality lies in the defendant having two opportunities to provide his evidence and come to court and explain it. Now, I must focus on the facts of this case, because what happened here was the defendant said, I have a lumber activity business, and I think it's important we go to it if it comes to it, because this is coming down to an interesting and narrow point here. We must go to...
In this case, I think there is evidence that the defendant put forward his case, it wasn't accepted. But when we're assessing the constitutionality of the legislation, we have to look at it more widely. And I'm not sure how helpful it is to go back to the particular facts of this case.
That's why I deliberately put in a far removed and, you may say, extreme example, but it doesn't seem to fall outside the structure that could lead to that defendant having all his property forfeited. Unless he could show that he got it from legitimate means, which he might not be able to do if he's owned it for very many years. And unless one can read into the Act a requirement of the court to act proportionally.
But presumably he could go into the witness box. So if we're dealing with a situation where the documentary evidence has been lost because of passage of time, that's not going to be a case where he's deprived of evidence altogether. He will go into the witness box and his evidence will have to be assessed then, presumably.
Yes. My Lord, the respondents say there will be one, in some shape or form, a defendant given an opportunity to rebut this presumption and give evidence will be able to come up with evidence, whatever the circumstances. And it mightn't all necessarily be documentary. It would be witness evidence. It might be neighbours. It could be, there's a whole gamut of ways in which people can provide evidence to prove how they came to have, because let's remember the focus of this. It's property that's a suspicion arises of engagement in money laundering. And so that bites, and the defendant has an opportunity to provide evidence and say, well, no, actually, in your example, my lord, I only had a small quantity for my brother or so forth. I haven't done this before, but actually I have a house. Here's how I bought it. I work, I have a job. They pay me in cash, but here's the gentleman who employs me. He can provide his bank account of how he pays me or something. The problem, it seems, if one is looking at constitutionality, are we trying to safeguard those people who have no explanation in the context of money laundering activity? Because that's what it must be. It must be someone who has no explanation at all for how they came by property, irrespective of the suspicions that arise in relation to money laundering activity. That is the only circumstance in which, in my submission, it could seem to be that this could be a disproportionate regime. But you've got the judge hearing both sides of the story. You've got two opportunities, not just one, two opportunities to demonstrate that your property doesn't fall within the suspicions of money laundering. And of course, it's important to note that under the provisions, there's a mandatory term there that the court will not even entertain the application for the temporary order, because the authorized officer must, it's mandatory, must provide an affidavit setting out the details and grounds for his suspicion. So that's the first step before anything happens. And that in itself, respondents say, is proportionate. My Lord Kerr, it seems that Walsh may have come back to my Lord. I'm not sure. I'm not sure I need to go, but I simply wanted to deal with what your Lordship said in relation to the classification, the nature, and of the offences. I hope my submissions in relation to that, which was troubling your Lordship, went, but it's as far as I could go, because there's also, of course, the difficulty that we're not instructed on behalf of the government. And that is a whole other set of detailed Brexit-like arguments one may need to have to go into.
Right, so where are we now?
My Lord, aligning those principles in any event on the Engel criteria to the facts of Williams's case, what the respondent says, it's targeted at the property and not the person. The supervisory authority has no authority to prosecute. Section 19(1) deals with making sure that the freeze order is in relation to the defendant's interest in the property and not wider than that. The Act, of course, doesn't require the frozen property to be linked to any specific offence. And the court need only find that Williams did something which amounted to engagement in suspicion of money laundering activity. And as I've indicated, it's a rebuttable. So respondents say that the Engel criteria are therefore satisfied. It's not about establishing guilt of Mr. Williams. My Lord, taking a comprehensive evaluation of all the Engel factors, as was preferred in Walsh at paragraph 29, in relation to the three factors, what the respondents say are these. There are no characteristics of criminal law, because in relation to the facts as they relate to Williams under the CFO, Williams was not charged with a criminal offence or a money laundering offence, contrary to criminal laws. Section 15 of the Constitution did not come into play because there was no criminal charge preferred. And similarly, Section 3, the individual rights and freedoms are not absolute. They're subject to the respect to rights of others and, more importantly, the public interest. So Williams didn't acquire a conviction when the CFO was made, and I read paragraph 23 of Walsh. It was not pivotal that there was no inquiry during the CFO proceedings into the criminal offences of possession of cocaine with intent to supply, of which Williams was convicted. Walsh deals with that at paragraph 26. And the supervisory authority, although a public authority, has no prosecutorial function or competence. That's dealt with at paragraph 29 of Walsh. There are, the respondents say, sufficient safeguards in place to ensure Williams would not be subject to a CFO if he's not able to satisfy the High Court judge otherwise. Paragraph 35 of Walsh. And section 9.4 of the Antigua and Barbuda Constitution, insofar as that's relied on, I'm not quite sure, relates to, it seems to me, compulsory purchase, but section 9 has a subsection 9.4, which again provides an exception where there's a contravention and there's a breach of the law or forfeiture in consequence of a breach of the law.
Can I just check, was section 9 relied on in the proceedings below?
So I'll just double check. There have been so many sections relied on this. Just go to the judgment of the Court of Appeal, which appears in the record 741. The discussion on the statutory frameworks in section 2371, 15.2a, 15.5, 18. It is 741 of the record, 742. Certainly those are the sections set out there.
So not section 9 in the court
9.
below? No.
They were in the appellant's case. I think
Yes.
that seemed to recall. Also keep me abreast of time, I seem to have. In terms of safeguards built into the CFO regime under the respondents say that the first safeguard is the High Court shall not, and this is in mandatory terms, shall not make an order under section 19, subsection 1c, unless the court has before it an affidavit of an authorized officer. So that's section 19, capital A, subsection 1, capital B, page 941 of bundle 1 of the authorities. So that's the MLPA. Secondly, my lords, it's important that the evidence in this case was before the court, and I'll merely refer to the pages of the record where the various affidavits of Ronald Christopher could be found, and that's pages 158 to 201, then 249 to 303, and 356 to 383 of the record. Next safeguard, the respondents say, and is a fundamental feature, is that the July freeze order was aimed at property belonging to Williams and not to the individual or his liberty. And that's section 19, subsection 2 of the MLPA at page 937 of bundle 1 of the authorities. Another important safeguard of the MLPA, respondents say, is that Williams was given notice by the supervisory authority on the ex parte application. And that's section 19, subsection 1, section 1, capital B, page 937.
Sorry, I don't do delay. What is the nature of the safeguard in section 19.2?
that it's aimed at the property and not the individual. So it has to, the order is made in respect of the interest, the defendant's interest in property, and not the defendant.
But how does that amount to a safeguard as against the deprivation of property?
Well, there is a comparison being made in the cases before the board of this discussion of in personam versus in rem, and it's simply that the CFO, or what the respondent says, the CFO does not deprive the defendant of his liberty, so it's not akin to a criminal conviction, and therefore the criminal standard of proof need not be applied, because that's also one of the
It's not really a safeguard, but it's an argument against categorising as criminal.
As criminal.
Yeah, I see. Okay.
It's the nature of the proceedings.
Yes. Thank you.
Grateful.
Could I just ask, is a defendant who is subject to a freezing order at the time of his conviction and who is fined entitled to pay his fine out of the frozen property? Or does he have to find some other property out of which to pay it?
There is a section, that's the interest, there is a section under the MLPA, my lord, where application could be made to the judge, I believe quite similar to the civil jurisdiction, to seek to release funds if it can be shown that whatever's been frozen in the property, some part of it needs to be released for purposes. It's section, let's just double check. It's 19.5, isn't it? My lord, can I come back to you with that in just...
You've very little time in which to come back.
Here we are. In relation to, so you've got at page 938 and 939. Yeah, there you are, dealing with expenses. So that is section 19.5. Yeah, make provision for meting out of the property various things.
Well, that wouldn't extend to paying fines, which I think was my Lord's question.
I mean, it would depend, well, it is, yeah. Or
And that's a section
living
that-
expenses or any other reasonable business expenses. Reasonable expenses in defending a proceeding under this act or any criminal charge to which the proceedings relate. Would that help?
Well, that's legal defences, legal expenses, I suppose, isn't it? It doesn't really help.
A fine is an expense in relation to a criminal charge.
Well, I'm sure that would be a submission noted to be used against you.
And the impression I have is that if the property is frozen, then subject to the regime in section 19.5 and 6, which makes express provision for certain monies to be taken out of that property, it's not for the disposal or use of the defendant while the freezing order continues. And so he couldn't use it to pay a fine.
Yes, exactly. I mean, the idea is to freeze the property. I mean, if one thinks of it logically, and nothing is done with it until such determination comes before the court, hearing both sides of the evidence.
Right.
My Lord, the points have been made about the opportunity for a fair trial and hearing at which Williams attended and gave evidence, and those are provided for in terms of the CFO at section 20, capital A, subsection 9. And 8. My Lord, in concluding and looking at the Strasbourg jurisprudence, my Lord, there are two cases. One of them is Gale, which the Lordship is well aware of. And there's only one paragraph there I wish to take the court to, because the point that's been made by the appellants is this is a case more akin to Gehring. And Gehring, my Lords, you may recur, so Gale is at tab 30 of Bundle 2 of the Appellant's Authority, Electronic The page is 1713 to 1753. My lords will recall Gehring was a case in which Mr. Gehring was able to, as it were, get his case ruled in his favor in the European courts. But and it's, in my submission, the appellants are probably trying to bring this within the facts of Gehring. What happens when you're acquitted and the facts, the underlying facts which would have sustained the acquittal are still being used in civil recovery proceedings. And so it seems to me, my lord, it's very important to bear in mind what was said in Gale, because Gale was the case where, again, Gale was tried and acquitted in Portugal, and on the part 5 there was an attempt to recover under the civil recovery regime, and the courts held in this court here, well, Supreme Court, your lordship sitting as the Supreme Court held that was perfectly proper. But the specific paragraph in Gale, which I wish to refer your lordships to, start at paragraph 54, because what is very good about Gale is that Lord Phillips undertakes in Gale a tour of the Strasbourg jurisprudence, and he specifically at paragraph 40 considered.
Could we have the electronic number, please?
Hearing. Electronic number, well, it's 1713 to 1753, and the page of the case is 2778, paragraph 40, I'm at.
2778.
Yes, please.
So it's 18 pages.
Paragraph 40 of that case.
It's 1733, I think, isn't it?
1729. Yeah.
No, 170.
And which paragraph are we on?
At paragraph 40, we see Lord Phillips taking a tour of what happened in Gehring's and Price. And he deals with this here. This question of benefits were discussed. And the last, at D of paragraph 40, he says the important point
paragraph
is...
40,
sorry,
right.
Paragraph 40 at D.
Well, I fear we will have to read that for ourselves, because
Yes.
time is up.
Yes, but the most important paragraph, I'm sorry, I'll leave on this paragraph, my lord.
You will,
It's
because
54,
Yeah,
yes.
thank you very much
54,
indeed.
yes.
we will read that.
Yes.
Thank you very much indeed. Mr. Taylor.
My Lord, if I could just start with something my Lord Sales raised about whether Section 9 of the Constitution had been argued below. I can give your Lordships the references in the submissions at page 675, paragraph 5 it was raised. Page 690, paragraph 19 is the respondents responding to Section 9. And at page 512 is the initial request, order for declarations that was made, the application which was made to the High Court. It's right to say the judge did not address them, but they were certainly raised. And page 671 as well of the submissions, thank you.
But I mean, the fact that the court didn't address them suggests that they weren't actually pressed on the court in the application. They may have been raised in the paperwork, but they weren't then argued.
My Lord, that's certainly right. Could I just take a moment? Yes. Dr. Dorset, who says that he was there and he did argue them. So they were raised, they were simply not addressed by the judge. My Lord,
And I'm so sorry.
Yes.
And what happened? You're talking about the first instance decision, is that
and in
right?
the Court of Appeal.
Right.
Some assistance to the court along those lines. If you look at pages 503, the supplemental affidavit of Ahmed Williams, and the declaration that you just sought from page 511.
Thank you.
Reference is made to Section 9. Yeah?
Right, thank you. I'm just mystified why the courts below didn't deal with it.
It was raised, my lord, that's as far as we can say. It wasn't dealt with. It was raised in written submissions and oral submissions, but it wasn't dealt with in the judgment.
Okay.
My lord, Lord Hodge this morning raised the question as to where the reference was in Weyer. I'd pointed out that the Supreme Court there had said that if an application was disproportionate, the court should refuse to make it, and that's at page 1673, letter D. In relation to Article 1, Protocol 1, the last sentence, the judge should, if confronted by an application for an order which would be disproportionate, refuse to make it, but accede only to an application for such sum as would be proportionate. My Lord Lord Briggs raised the question this morning as to whether there are other civil regimes in which civil courts are required and do consider specific elements of criminal offences. I think my Lord raised in relation to insurance and contractual
inheritance.
My Lord, we have spent a little time over lunch looking into that. It is an involved matter, and I would be grateful if we could have 14 days to put in written submissions on that point.
Well, could you manage in 7?
My Lord, yes.
Yes, thank you.
Thank you. My Lord, just taking points briefly, at the Section 6.3 point, Misuse of Drugs Act, and the question of whether the judge misunderstood or tis. With respect, that's not the relevant issue here. The two relevant issues are whether the judge had the power to do as he did, and whether it was on the right basis or not is irrelevant. The fact is, he did not convict on that matter. In terms of Section 19.1 and the various bases, it is a matter that we say that it's essential for the prosecution to pin their colours to the mast, because otherwise we get into a situation, as happened with my Lord Briggs and Lord Hodges' question to the respondents about the 30 days issue and when it's charged and when it lapses. And we end up in a situation where the prosecution are forced to fall back on the fact that, well, it's so wide that really it doesn't matter. And that's the real danger here, and the need to specify. Could I just refer your lordships, give your lordships the references to page 794 to 799 of our case, paragraph 70 to 96, where we analyse the various bases of the application and the granting. In terms of proportionality, my own friend Ms. Artesi says that this is analogous to the regime in Walsh. We say that that's simply wrong, is that the target in Walsh is the property, the target here is the person. It's not restitution. And my learned friend's suggestion that, or submission that the MLPA is preventative really pulls it into the realms of a criminal regime, because it means that it's not simply recovering the benefits, the proceeds of crime, but going way beyond that. The suggestions that Section 19B and Section 20A 1 and 2 allow for a regime which has safeguards to prevent an unjust and disproportionate order simply does not hold. The wording in subsection 2 of 20A at page 951 is mandatory. There's no reference at any stage, and indeed my learned friends, as I understand it, have not put forward that the regime has any procedure whereby the question of culpability and benefit and proportionality can be argued by the defendant in order to reduce the level of the compensation or the confiscation order, the civil procedure order. And the most that can be said is that the defendant has ample opportunity to put forward arguments to show that the interests in the property are not related to drug dealing or money laundering. There is no opportunity and no procedure within the regime to say, actually, the amounts involved here are so low, and I started off my submissions this morning, it was around £15,000 was the purchase price of the drug. There's no evidence on the street value, but $15,000, which ended up with a 5-year term of imprisonment, $100,000 fine, and nearly £800,000 in confiscated property. Now, my learned friends say, well, of course, it's up to the judge to reduce that, but what flies in the face of that is, one, the supervising authority's application relied on the full interests of the property. There was no suggestion that it might be below that. That's what the judge made the order for. And certainly the understanding or the submission that Section 19B and Section 20A somehow provide an equivalent safeguard as appears in the Proceeds of Crime Act, and indeed all the other legislation that we looked at in the Eastern Caribbean, where the courts have a specific direction not to make an order if there would be a serious risk of injustice. That's not what is mandated here. In fact, it's quite the opposite. Once the boxes are ticked, the court shall make the order. My Lord, one final matter, in fact two very short matters, is one is, my learned friends say, of course, he had the opportunity to put forward evidence and everything else, but if this is simply the wrong venue, and it should be in a criminal venue, then the fact that he's able to do these things is really irrelevant to the lawfulness of that procedure. One final matter, it's, and it really goes to the core of the case. Section 20A, subsection 3, requires the High Court to make a finding that the defendant committed a particular offence of money laundering activity. And if one goes to section 2H, section 2.1, money laundering offence, it lists, yes, 909, thank you. It lists specific offences. My learned friend says that this is not a matter where, a procedure where it's necessary to find the guilt of the defendant in order to trigger the targeted property. If one reverses that question and says that the court found that the defendant was not engaged in money laundering activity, that would be the end of the procedure. And that really, together with the fact that if the defendant died, was not known, was unfit to be involved in these proceedings, focuses the light clearly on the fact that this is criminal, focusing on the defendant rather than on the property. My Lord, unless I can assist your Lordships further. Sorry, can I just take 1 moment? Yes, Dr. Dawson points out, and it's right, it's part of the proportionality and the need for these safeguards is that there is no time limit going back as to how far the property that is subject to the confiscation order can be made. page 638 of the bundle, paragraph 47 in the judgment of Justice Henry. My Lords, unless I can...
Thank you very much indeed. Well, you should have 7 days in which to make the written submission, Mr. Taylor, and that should be transmitted electronically to the court and to the respondent. The respondent shall have 7 days with which to reply, if it chooses to do so. And again, there should be electronic transmission to the court and to the appellant. We're very grateful to Council for their very helpful submissions. The Board will take time to consider what advice they will humbly tender to Her Majesty. The Court is now adjourned.